All right, guys. So I have some news on the think tank. We are rebranding it because apparently everybody and their mama have think tanks. So we are rebranding it. It is now going to be called Level Up with Laiken. So I just wanted to welcome everyone to this week's edition of Level Up with Laiken. If you are looking for tangible tips, and the mindset to grow your law practice, please hit subscribe. I interview a new lawyer every week who will talk about the tips and strategies they've used to successfully scale up their practices. This week, I am very excited, and Matt, forgive me if I screw this up. I promise you I practiced this. We have Matt Clendenin. How did I do?
You nailed it.
Because your last name was a little difficult for me. Matt Clendenin owns the Clendenin firm. He primarily practices personal injury. Matt, I did some research on you. You have an interesting story that we are definitely going to get into. One thing I found very unique about you was that your law practice started in 2007 as a paralegal.
No, started in the trenches.
That's amazing. What an interesting breadth of knowledge to come into your own law practice with, because you got to see it on the support side. So how did you get into becoming a paralegal?
Worked as an assistant librarian in college, and I kind of liked like books and reading. I was kind of a nerd, and then you know how it is. Someone's like, "Oh, you like to talk. You're very outgoing. Like you should think about law school." And I'm like, "No, that's crazy. I would never become a lawyer." But like, like I've seen some TV shows. It looks kind of cool to be in a law firm, so maybe I'll be a paralegal. And so, um, and man, those programs, I don't know if you guys have ever, if anybody else is a paralegal here, it's like an intensive 3-month program to get it's almost like a law school crash course. And you do 3 months, you do all the major courses. And at least back then it was like $5,000. I was like, why would I not do this? This is great. And then I loved being a paralegal, and the rest is history.
Man, I actually never get a straight answer from the paralegals that I interview about what it is exactly that they're learning. Because if I ask them, do you guys do discovery? What do you learn? They say no. So I'm always interested in what do you learn in paralegal school?
I feel like paralegal school is just like really short versions of every law school class. I mean, like I took a Civ Pro class, I took a crim class, I took a research and motion writing class. I mean, it's like they do teach practical stuff. But it's not like there's like a class that's like how to file class, or like how to calendar class. Like they don't have those classes. It's just like law school, but kind of truncated. And then yeah, but they're heavy on experience, right? So at least I went to UCSD's paralegal program, and they had a component where you had to do an externship and go work in a law firm. So they try to get people up and running, doing real stuff. But yeah, it's kind of weird. It's kind of like miniature law school, but then you're not really going to do what a lawyer does. You're going to go and do different stuff.
Okay, all right. And then I learned something else about you that we have in common. And
What do we have in common?
It is near and dear to my heart. You won your law school's intramural competition for moot court.
Yeah, moot court. I love it. Moot court was great.
And I feel like I'm interested to know whether this had the same effect on you. I mean, obviously, nobody incurs, the law school load and the debt unless they have a pretty good idea that they want to be a lawyer. But what really solidified it for me, like when I was like, okay, this is what I want to do. This is my jam. I got in the zone, was when I was in the final round of the intramural competition. And for Southwestern, they did it at the federal courthouse in Pasadena, and they flew in 5 state Supreme Court justices. So it felt real. And I remember arguing that final round, and when it was over, I was like, this is it. I got to do trial work, even though it wasn't trial advocacy, just creating and crafting the argument and then delivering it and telling the story and answering the legal questions felt so good to me. Did it have that kind of effect on you too?
For sure. Once you get the taste of like I call like trial like combat, but it's like legal courtroom combat. Like once you get that taste of the the competition, it's stuck, right? So it's like whether it's a depo or a motion, or I mean, if you get to argue appellate arguments, like, just like very cool to be in that moment, kind of doing that stuff.
Yes. Yes. So let's talk about you went to, a program for paralegal school, and then did you work as a paralegal?
Yeah. I worked at a couple like small practices, like a family law practice, a PI practice. But then I also did several gigs at like some of the larger firms like McKenna Long and Aldridge down here in San Diego. I don't think they exist. I think it's Aldridge Pite now. They're like a big defense firm. Latham Watkins, they also don't exist anymore. So I did a couple big firms as a paralegal, and then shortly after that's where I switched to law school, got into law school.
So what made you do that?
At the time, it was I wanted to do more of the fun work and less of the grunt work.
Okay.
And then I also thought I'd make more money, but then of course 2008 the crash happened and all that. And so my first job as an associate lawyer, I made less than I did when I left as a paralegal. It was like a big kick in the nuts.
But what was your, like, when you're doing the grunt work, were you looking at the things that the attorneys were doing and thinking to yourself, oh my gosh, I could totally do that?
As a paralegal, it's kind of like a black hole of like what the lawyers actually do, because you do like take a motion, right? So like the lawyer drafts it, the paralegal helps them draft it. Maybe the paralegal does a little law and motion work and finalizes it, gets it filed, calendars it. But then the lawyer just kind of disappears in a black hole and like actually goes and argues the motion. And so I feel like as a paralegal, like paralegals don't have the full picture of what lawyers do. But in my head, I was like, oh, they're leaving to go have fun. I'm stuck here in the office and I just have to like start the next project while they have fun with the work that I did. And so I always thought like, hey, I don't know. And I'm a competitive person too. So I wanted to like, I felt like, why am I here when I could be here? But yeah, I don't know. There's like an alternate reality where like my life is much less stressful and like I just stayed as a paralegal. That probably happened in like some alternate reality. And I'd probably be like perfectly happy, but I love being a lawyer. So that's great too.
Okay. And then given that you did have exposure to a couple of different backgrounds as a paralegal, why did you choose personal injury?
In law school, I thought for sure I'd be a public defender. I kind of like the David versus Goliath thing, right? You got an individual charged by the state. You don't have to worry about billing because it's all public entities anyways. And at the end of the day, you're trying to help somebody that's in a tough spot. And then the first job I got was just kind of rent. I fell into a personal injury job at a mid-sized firm in East LA, Glendora, and I loved it. And so I just stuck with it. But a lot of the similarities are there. It's like I don't have to worry about billing, right? You handle your case, the client trusts you, you're helping them out, they're in a tough spot. And there's the David versus Goliath, right? We represent individuals versus billion-dollar insurance companies. So I think there's a lot of similarities between public defense work and private PI work.
Do you watch Goliath?
No, is that a show?
Yes.
I'm totally out of it. What's the show about?
It's Billy Bob Thornton. He's a lawyer, comes from a huge firm, has a fall from grace, and he lands on this case that turns out to be much bigger than what he thought. And it's literally about him going up against his old, multi-million-dollar firm. I mean, it's crazy, and everything that they do to try to take him down, and how he just keeps climbing his way back up, and he just won't let go. It's really interesting. It's on Amazon Prime, but it's the same.
Check it out.
Yeah,
Sounds
it's
good.
the same theme as David and Goliath. He's David.
Oh,
so
right.
Yeah, but he used to be Goliath, so that's what makes it so interesting.
I've never been Goliath, so that's easy for me. I'm always the small guy.
not Goliath either.
Yeah.
But I think that's what impassions me, is the fact that I'm not Goliath. Like, I look at Goliath as State Farm, the Auto Club, Sedgwick. Like, those are my Goliaths, and I love going up against that and settling cases and winning a trial, because, like, see, I got you, So yeah. Especially when they underestimate you. But what was it? I know you mentioned, going up against the Goliath. Is that what fuels you in personal injury?
No, that because they're always dogging our clients, right? Like they never give our clients a fair shake. Like if they did, like our industry wouldn't exist, right? If insurance just did what it was supposed to do. And so we're always fighting the good fight. And I really love that. Like I've got a Fred Loya case right now. I don't know if anybody else got this letter where I sent a demand in, and then they sent a letter back saying, we're a Texas-based insurance company. The Texas governor has issued his state of emergency, and we're short-staffed because of COVID. So we're not going to even review any demand letters until the Texas governor lifts his emergency order. I don't know if anybody else got that letter. I was like, you're out of your goddamn mind. Like, review my demand. Like, it's just bullshit after bullshit. And so, yeah, that definitely fuels me.
People paid for that insurance. Are you kidding? That's what insurance is for.
Exactly. I'm like, show me where California Department of Insurance relieved you of your duty to process claims. Like, get out of here. I also really like the client interaction. I know that there's like, I guess I'm one of those lawyers where like client always has your cell phone type thing. And I think as younger lawyers and as smaller law firms, that's like our advantage over bigger personal injury firms, is that like, hey, you know, they've got my cell phone, they can call me anytime. You know, it's kind of a pain in the butt for work-life balance, but I do like it. Like, it makes me happy to be wishing a client happy birthday, or, you know, something goes down and they need help, and so I, you know, try to help them out. I like that part of my practice too.
Okay, now we're going to get into that, because we at JHQ know that you are the client whisperer.
Yeah, dude, I love witness prep.
I know you do. And we're going to get into that, but I want to explore. So you go work for these different firms, but we have your own firm. So how did you come to that transition?
That was another, like, a whim of fate, where I was kind of progressing at that PI firm in Glendora, and thankfully my compensation had gone above at that point what I was making as a paralegal before. So things were getting better, but my wife had just finished her master's program at SC in public health. And so we both went to college here in San Diego. That's where we met and got married. And so after she finished her grad program, we said, hey, let's go back to San Diego. And she got a good job in biotech. And so that kind of gave our family the financial stability that I said, hey, you know, let me go hang a shingle. And so that was the transition. But it was tough because it didn't quite, I mean, I got a lot of cases and then got buried in litigation costs and didn't have a good plan to fund all those cases. And so after 2 years on my own, I joined another lawyer, Steve Bronson, the Bronson firm here in San Diego. And I worked with him for, 3 years. And then went back out on my own. So that's kind of the transition where my wife and I came back down. I hung a shingle. It sort of worked out, but didn't quite have the setup for like funding all these cases. Joined another lawyer, loved it, but then eventually like got the stability to go back out on my own.
So let's break that down, because when you started, how, you know, going out there and just hanging your own shingle, how were you able to amass the cases?
That's the funny part. I was always worried that like nobody would hire you, but I feel like there's just a huge spectrum of cases, from shitty cases to like perfect cases. And as a younger lawyer, you just have to cut your teeth on the tough cases that other lawyers will refer to you. I mean, I feel like if you put out an email on the listserv right now that says like, hey, who's got like low value, like, you know, bumps and bruises, rear enders that like you want to fight against Allstate where they're offering less than the meds, you'd get like 20 cases in half an hour by like asking for that. And there'd be plenty of lawyers who would love to offload those cases for a young lawyer who's going to fight hard and just work them to death.
Is that what you did?
That's what I did when I first hung my shingles. I networked with as many lawyers as I could. I went to every bar event, you know, asking for cases, and I did hourly work too. You know, law and motion work, appearances. I did anything just to try to like make it work. Because when I opened my bank account, I remember I put a $500 deposit into like my first law firm's operating account. Like that was my operating fund. It's like, all right, here we go. And you know, it was tough for a few years, but you know, we made it work, and then eventually found a better spot joining the other firm.
And then you obviously built up your coffers in the meantime. And once you were more equipped to handle case costs, etc., then you relaunched on your own?
Correct, because I had negotiated. I know this is like the eternal debate for associate lawyers of like, do you pay them a flat salary or do you give them a low salary plus like a bonus structure? And so I had the bonus structure. And so yeah, after a few larger cases that I had brought into the firm, like that bonus structure, essentially like I put that money aside.
Oh, so did you close up your firm and then take your cases to the new firm, and then once you got a little more stable, then you opened your firm again?
I had about 40 files and about half of them were in lit, which like if you can do the math, you're like, I had no money and had 20 litigation files. It's like that ended up pretty poorly pretty quickly.
Did you take and you took those with you?
Yeah,
Okay.
yeah. So I just met with the other lawyer, and I mean we hit it off. We were good friends, and so we kind of negotiated. And I'm like, look, I got a ton of files, and I think there's a lot of good fees to be made here, but I need the help with the funding, and so we merged. I mean, sorry, that's not true. We didn't merge because I was an associate lawyer, so I never became a partner. But
Okay.
I brought my own files. I just kept working my own files, and but I had like a bonus structure worked out with them, so that's how it worked out.
Got it. Okay. And then you went ahead and did a take two. That's unusual. And I remember when I was researching opening my own firm a long time ago, I did it for like a couple of weeks. I was married at the time, and I took on one family law case that was just, let's just not. And my ex-husband was like, nope, you are going back to work. And I was like, so I went back to defense, and I was so miserable. And then, I went to a plaintiff's firm, fell in love with the law again. And then after that, my life changed. I was now a single mom, blah, blah, blah. And it just made more sense for me personally and professionally to open my firm again. So I did it again. But I remember the one thing that scared me so bad about that was when I read this book. It's a really super thick book. Can't remember who wrote it, but it's like the book that a lot of people read when they want to, like how to start and grow your practice or something like that. And they said, just be very careful in the preparation phase, because oftentimes people who open their own firms, if they fail, they're almost statistically guaranteed to not open it up again or fail a second time. And that scared the hell out of me. So when I closed it after my first couple weeks stint, I was like, okay, that's it. I guess I'm going to be someone else's employee for the rest of my life. I'm glad I did not listen to that advice. I now look back and wonder how true that is. Clearly it wasn't true for me. Clearly it wasn't true for you. But were you nervous the second time around, or did you just hit the ground running and, with a I can't fail attitude? Like what were you thinking?
I'm always nervous, right? I mean, we all are always nervous, right? I mean, that's the nature of contingency fee work. If you don't got the freaking stomach for it, get a different job. But yeah, no, I hit the ground running, and I felt a lot more confident that I had I mean, it wasn't a ton of money, but I had like money set aside to help fund the practice. And so that gave me the confidence to just look, I know I can do the law part of it. I know I can try cases. I know I can do a good job working up files. And the other thing too, that I also was a lot better at was over the last 5 years, right? Because I had my own practice for 2, and then I was with the other firm for 3. So over the last, and then I was at my first firm for a couple of years. So I felt like once you get around like the 10th year of your practice, that's where you kind of like really hit your stride of like, hey, like I know what I'm doing. I've got relationships. And so for me, part of the relationship was funding all these cases. So like instead of just telling a lawyer, yeah, man, like refer me that case and let's do a fee split for a third, right? Instead of just doing that, now it's, hey, let's have a conversation. Do you want to go 50-50 on this and you front all the costs and I'll do all the work? Like let's have more of a division of labor versus just me taking on more and more case files all on my own. And so having partnerships, like Kyle and I, we're co-counseling a case right now. And so it's like, hey, that kind of partnership makes you less nervous because you not only do you have the funding, right? You're sharing costs, but you're also sharing the work. So it's like, all right, like the risk is spread out, but of course, so is the reward, right? So so I'm a lot better at that this time around, and that helps me have the confidence to succeed.
So aside from the money, was there anything that you took from your first experience into your second experience to, make you feel better about succeeding? Anything you did differently? Anything you learned from the first time around?
Yeah, so I would always have at any given time like 3 or 4 dog cases, and I don't mean like dog bite cases. I mean like shitty cases.
I got it.
Like a dog case. And at any
Yeah.
given time, as like a brand new lawyer, I'd always have like 2 or 3 of them, and
Okay.
I couldn't figure out why. And partly I kind of thought that that was just sort of like what all lawyers had to deal with, of like, hey, you got some winners, you got some losers, you just kind of deal with it. And then as you get older, you're like, wait a second, like, no, like learning to say no is like probably the best thing you could ever learn to do during case selection. And so learning to say no more, and having the confidence to get off of a case. If you're like, look, if I investigate the case and find out that it's a terrible case, like, you need to tell the client that. Be like, look, I've done the work, I've investigated your case, I didn't promise you anything to begin with, and like, we just can't move forward. This is, for whatever reason. And so these days, I'd like to think I don't have any dogs in my case files, but just fighting to do that is a key lesson that I learned. Like, those cases will sink your practice, just from the amount of time that you spend on them, and then God forbid you get into like experts and stuff.
I've done it. I've done it. Yeah.
I'm basically the dog now.
Yeah, it's funny because during my prep call with Arash Hamapur, he told me that, because I was under the impression that as a trial lawyer, you want to try anything and everything, just get into the courtroom. And he said, no, don't do that. He said, the cases you're going to lose, he was like, they will eat your soul. Don't do that. And it was a good lesson. And there was a case that I had getting ready to go to trial when that happened, that I had to have a little come to Jesus with the client. And I'm like, look, I can't win this. There's no way. Aside from the fact that, I didn't think the jury was going to like him at all, because I didn't like him at all. But I told him, I was like, you're going to have to sign a release, basically releasing me from, any and all liability if we lose, because I'm telling you right now, we're going to lose. But the lesson I got from Arsh Hamapur is, you got to say no. And one of the benefits in terms of, pre-lit files, and not just the cases that are going to trial, when I first opened my practice, I went to Min Nguyen. And I asked him for advice, and he said, don't be afraid to say no, because the case that you feel like you have to take because you need to increase your caseload, and that case is crappy, that case is going to suck your life for like 2 or 3 years. And he said that it happened to him. So now there were some cases that were, I don't want to, misrepresented to me as being more valuable, that when I finally got in and dug in, I was like, oh my gosh, this is a terrible case. We've got to, cut bait and let it go. But I have learned the value of being more selective. The other thing that I noticed from your website was you mentioned that you manage your caseload. So you keep your caseload smaller so that your cases get more attention. I wish I had learned that lesson when I started my practice, because I am now learning it. And I think that's really smart. What led you to that tactic?
I think it's the amount of work that I like to do on files, right? Like, I feel like if you make a commitment to your practice, you're like, look, like, I'm going to run focus groups on my cases. I'm going to do witness prep for all my depos. I'm going to litigate the hell out of every file I have, right? Like, I'm going to do one demand and then file within 90 days if I get yanked around. I mean, like, those types of things, all of those things take time, and they all take a ton of work. And so if you want to have 400 case files, which I know some lawyers do, you're like, you can't do that. And so I think that's where I made a decision somewhere. It was almost like a subconscious thing of like, look, this is how much time I'm going to spend on each file. And that's not changing. In fact, if anything, I want to spend more time on each file. And so when you have a case that comes in and you're like, oh, I think if I like do a demand, I could try to squeeze, 10 grand out of this file, or 15 grand out of that file. And then you start thinking like that, and you're like, wait, no, but even if I did get the 10 grand, if I did everything I want to do, I wouldn't be making money. And so that helps you say no, and that helps you maintain keep your case list low.
Is that working out for you in terms of your profit line? Keeping your cases?
Yeah, so that's the funny thing. I don't like, maybe that's just the natural progression as like, your practice is around for longer, you start getting a few more good cases and less small cases. So maybe it's just the natural progression. But yeah, I do feel like if you just try to keep your caseload low, get rid of all your dog cases that are just sucky, and then the finances follow, right? Like it just kind of works out. So yeah. But yeah, no, it has been, because you keep your case low, then there's just less cost involved. There's less time involved. You don't need as much staff, right? Like I have a part-time associate that works like 10 hours a week for me. It's like not very much. And then same thing with a paralegal. So it's one of those things where you really don't need a ton of staff if you keep your cases low.
Do you delegate? Is your associate attorney who's working for you part-time, does she take over certain files, or do you delegate tasks on files to her?
A little bit of both. Right now she has like 2 smaller pre-lit cases that she's just running on her own with my supervision. Like we meet every week, and we talk about what to do. And then in one lit case that she's like, technically it's her case, and I'm working with her, but mostly it's delegation of like, hey, I need you to take this depo, or I need you to write that motion, like that kind of thing, where I'm still the lead lawyer, but it's more a delegation thing.
And when did you come to the point where you knew it was time to hire?
Just the end of last year, so just 6 months ago. And so and it was the best thing I ever did, like, because doing the part-time thing also gives you a little bit of confidence. So like you can scale up those hours or draw down those hours as you need. Of course, you have to find the right person, right? Because some people say, look, I need a full-time job. She's kind of I wouldn't call her a stay-at-home mom, because she works, she's a lawyer, right? But she has 2 kids that she takes care of a lot. And so for her, because her husband's in the Coast Guard and he gets deployed. And so for her, this is perfect, where she's like, I can just work some hours here, work some hours there. Matt's really flexible. If a big project comes along, she can set aside the time to do it. But it's, I think having that flexibility is really critical, because there's absolutely no way that I could financially support a full-time employee right now. It's just that, my caseload doesn't demand that right now. But that's the benefit of keeping your case list low, right? I can do that. If I had 100 files, I would need a full-time employee. Like it just, so I think that finding that balance is an important thing.
Another thing that we had talked about in the past is getting super clear on what kind of firm you want to have, like what your end game is. Do you have an idea of what kind of firm you want to end up with, or do you have it now?
I want to stay small. I don't have any aspirations to become a 20 lawyer firm. I think I would like to grow a little bit into like having several full-time employees, and maybe that'll come in time. But no, I don't. But I really just want to keep my caseload low, and I want to continue to try cases, which of course that's hard. Just so in the civil world, it's hard to get any trials, right? And then even when you can get them, now we got the pandemic, and then even after the pandemic, it's like a cost benefit analysis of like, damn, this is expensive, and I have to disappear from my practice for 3 weeks, and then what happens with all the other cases? So it's hard, but that I want to do that, and so staying small and staying lean, I think, is helpful.
So, how did you get there? Because how did you get there to being? You go from being a paralegal to a lawyer to a trial lawyer. Did you know when you became a lawyer that you wanted to be a trial lawyer?
Well, remember my first job was at a mid-sized PI firm up in East LA. So like I guess that was my training as a new lawyer, was like watching PI trial lawyers, right? So it's like that's kind of what I saw older lawyers do. And you second chair a few trials, you do all the trial docs for another lawyer. I mean, you start to like get involved in the trial process. And so I guess it was kind of natural. It's just that's what I never had a different job. So I never worked at a corporate law firm where you just do transactional stuff. Or I never, worked at a wills and trust practice where it's all, um, non-litigation. So,
But I know plenty of lawyers who second chair trials, and it's through that experience that they're like, nope, not for me.
sure.
Not
Yeah, I mean, yeah, of course, right? I mean, if somewhere along the line I was like, I don't like this, I hate it, I wouldn't be here today, right? And so somewhere along the line, I really fell in love with it, and here I am.
That resonates with me because I feel the same way. Like I had this conversation with a lawyer who I actually, got some cases from, and he's like, I don't like the courtroom, I don't like trials, I don't like the dirty bathrooms, I don't like the nasty food. And I was like, oh my gosh, I will eat that food all day long. I will use that bathroom all day long. Like, I love the smell of a courtroom. Like, I do what I do, one, because I do like most of my clients. And I do genuinely like to help people. I love the fight. Like, that is why I became a lawyer. I love being underestimated. I love that musty smell of a courtroom. I love it. Like, I love the formality of the courtroom. I love I don't like writing motions, but I absolutely love arguing them. Like, my end game for my firm would be to have a fully staffed practice so that the day-to-day is still happening, the clients are being taken care of, but I want to come in for the important depots. I want to come in for the trials. Like, I want to bring it home. That is my jam. That's why I became a lawyer. And I feel like some people are either wired that way or they're just not wired that way. And it sounds like you were wired for trial.
I guess so. I like it.
And I feel like in a certain way that helps us also help our clients, because we get the unique view of seeing how the discovery plays out in the end. What is going to matter, what's not going to matter, what is going to be admissible, what's not going to be admissible, what's going to help for discovery but is not going to come out of trial, which witnesses are going to be impactful. And that, I think, is where you particularly are unique, right? I was listening to a law firm marketing book, and one of the things that the guy was saying was, you got to find your niche. And you are the client whisperer. I named you that. Sorry. But I kept, and how I found you was on JHQ, and people kept hiring you to prep their clients. And they're like, oh my gosh, I could not get across to this guy. He worked magic. The client just did so well. There's gotta be something about you that allows you to connect to people in a way that a lot of us cannot.
Everyone asks me this, and I always feel a little bit embarrassed. I'm like, there's no black magic, right? Like y'all lawyers everyone is qualified to do what I do with like the witnesses. Like, really, I just feel like you got to set aside the time, and you got to be a good listener, right? And so you got to build up that credibility with the client so that they'll actually pay attention to you, and they need to be comfortable. And like, to get a client comfortable takes time, especially when you're talking about a depot. And especially if you're talking about a client who really, like, depending on the practice, it's like, dude, the depot could be the first point that the lawyer has really started to connect with the client, right? I mean, because, during the demand phase, the discovery, you're just kind of like,
working it out. Yeah, you're working it out.
Yeah, you keep the client updated, but you're not necessarily like in meetings with them or spending a ton of time with them. And so then the deposition rolls around, and people are shocked that like their client's not listening to them, or they're shocked that like, you're trying to like get something across. You're like, okay, we need to talk about open and obvious. So like, let me tell you, like, when they ask me this, don't say this or say that. And you're like, oh my God, the client like did exactly the opposite that I told them to. It's like, well, yeah, because they weren't comfortable. Like, they didn't, like, you hadn't gotten to that point yet. So you can't expect them to do the heavy lifting with like these tough deposition issues if you haven't put in the foundation and the legwork as the lawyer to like make them confident, help them understand how the process works, and then listen to them until they're done telling you all their concerns, because that's the only way you're going to get them to be confident.
And I know that this embarrasses you.
Well, what embarrasses me?
Talking about your talent to connect to people, but I want to dig in there because I feel like one of the things that people find so helpful about what you do is it seems like you overcome roadblocks that maybe the rest of us don't detect with the clients. Because somehow these people are not performing, in a stellar manner, and then after you prep them and they get to their depot, now they're relatable, they're likable. My question to you is, what are the issues that you see when you're prepping the client? What seems to be the sticking point that you seem to be able to break through to get them to be comfortable? Is it time? Is it patience? What is it?
No, that's a good question. I mean, every client has their own issues, right? Like I was just working with a witness last week where he was like incredibly nervous. Like that was his problem. Like, and he was like I practiced the admonitions with him, and then he literally said, I didn't catch any of that. I didn't understand it. I was really nervous. Like, could you say it again? Right. So it's like that guy has like a unique issue of like listening, and he's so nervous that he can barely like focus. But so I mean, everyone has their own individual issues. So that's hard to answer.
If you get that person who's nervous, I'm sure that's not the first one you've had. I mean, I get clients who get really scared and they're really nervous. Like they mention the penalty of perjury and they fall apart, right?
Yeah. Well, I feel like for all the problems, there's like a few central themes that like you really have to help a witness understand. And I feel like one of those is control, which is that like the witness themselves is in control, right? Like it's like
Okay.
it's their testimony. They're the only one that's under oath, right? Like nobody can make you testify to anything that's not true, that you don't want to say. And
Okay.
so I think that element of learning that you're in control helps everybody with a lot of their issues of like, hey, this mean lawyer who's going to ask me all these mean questions or whatever, they're not in control. Like I'm in control. So I feel like that's really helpful no matter what the issue is.
Do you feel like when you put them in a position, when you let them know that they're in control, you put them in the position of power so that they don't feel like they're at the mercy of someone else and therefore they're not as nervous?
For sure. But not just nervousness. I mean, it's everything, right? Like if they're part of the story is like, look, like I know that this injury seems minimal, but like it's really impacting my life. Like if they're in control, they're not going to let the other lawyer get away with all their like, their passive aggressive questions. Do you have any future medical treatments currently scheduled? What sorts of things can you do, can't you do? All sorts of things, right? Then the client's going to take control and be like, no, like I see how you might think that this is a minimal injury because of X, Y, and Z, but like it's not. It's impacting my life, and here's why. And so like that's like they took control of the situation and like made that. I call them major truths, right? Like you have like major truths that you focus on, and so having them have control lets them focus on their major truths.
Here's a classic client scenario I run into. The client who is impatient, who feels like like they own the process a little too much. They get easily angered. I had a client the other day, I kid you not. He was irritated that the depot took so long, and I told him, hey, I can't control how long it's going to take. It's up to the defense attorney. It's her depot. I definitely would set aside the day, and hopefully, and sometimes it takes 2 hours, sometimes it takes 5 or 6, right? And this guy was so irritated because he wanted to drive home because he had an hour commute. He got in his car. He put his cell phone in the cup holder, and the court reporter's going, "Sir, is that safe?" And I'm like, what are you doing? Oh, and thank God the defense attorney had some technical difficulties. We had to call the depot, go in for second session. Yeah. I was like, oh my gosh, and he was having trouble either hearing her or understanding, but he came across as just angry. And I tried to tell him before the depot, like, look, if she likes you, this is going to add value to your case. If she doesn't like you, it's going to do the opposite, right? You got to be nice, and I just couldn't get that across. What do you do with the clients that you feel they just come out of the gate just mad?
So I mean, you got to understand why, right? I mean, I don't know. I don't know why he was mad. Maybe he was mad because he like needed to get home to see his family, or maybe he was mad because he's going through a divorce, or maybe he's mad because he doesn't care about the case. Or I mean, right? You got to figure out why. Once you know the why, then you can start to work backwards and try to connect with the client and reassure them with their problem or address their problem. I mean, for all I know, maybe you're a crazy guy, Ashley. Like he could have been like maybe he needed to schedule 2 sessions, and so like that's something that he had to take control, or you and him had to take control and say, look, we can only do 2 hours today. I'm sorry, that's what his personal life schedule is. So like we can do 2 hours and we'll schedule a second session. And like you guys are in charge. Screw the defense lawyer. Like you get to do that. It's always their concern, right? So hey, you look really angry. Why are you angry? Can you tell me a little bit more about that? You know, what's going on? Do you think, are you worried that you're going to be angry during your depo? How do you think being angry could affect your deposition? What are some tools that we could work on together to try to be less angry in your deposition? You know, like sometimes it's anger at the insurance company, and then like I feel like that's like a good thing. You're like, great, let's take that emotion and like let's channel that into a positive direction. But sometimes it's just like it's if you so that I feel like there's 2 clients that are just impossible to prep, and one of them is someone who just doesn't care about the process, and then the other one is the one who thinks they're too smart for the process. So
Yeah.
like especially like other lawyers or like doctors, sometimes there's like, dude, you can't coach those folks because they think they're too smart, and so it doesn't matter what you do.
I feel like they do the most amount of damage.
Oh no, for sure. No, it's like they're too smart, but they can't realize the damage they're doing to themselves. But like someone who's angry, like usually that's a fairly fixable, addressable problem. Because I mean, I believe that people aren't just angry because they're angry. I think they're angry because of something. Like there's a reason they're angry. And so you can address that as long as they're interested in the process, right? Like if your client's angry and he doesn't care about the case and he doesn't want to work with you, I mean that I mean, unless that's like a 7-figure case, I mean that's just something that you don't want to be working with them, because it's like if you don't care about it, I can't do anything for you. And you want to work through it and figure it out, and let's do this together. Like I'm committed to you. Let's figure it out. Why are you angry? What's eating you up?
And I'll tell you, in terms of my client, he was like, this is taking so long. Why do I have to do this? Why can't you just settle it? And I'm like, I would love to, but we have to do this first. You got to get deposed first. A lot of, and I explain to my clients, a lot of insurance companies require that now. It's almost like just their policy and procedures that the depositions have to happen before they can settle it.
I mean, look, if you want the insurance company to write you a check that's even modestly big, like they're going to need to depose you. And that's just they have a right to investigate. If you're suing and asking for money, it's perfectly fair that they get to talk to you and ask about what's going on.
So in terms of the 2 other clients that you say are just impossible to coach, do you consider those things when you do your intake process?
For sure. And what I really like to do is, I always have like an intro call with a referring lawyer to say, hey, okay, what's going on? What are the issues? And usually the referring lawyer will be able to identify one of those, right? Of like, look, this is just a really angry person, and like I'm struggling with how to get them presentable for depo. Or hey, like I saw John Roach just jumped on the call. He was the one that we were working with, the client who was he had like the nervousness, like he couldn't focus or answer questions, And so the referring lawyer knows those things, right? You all know your clients. And so when you come to me, I say, hey, what do we need to work on? And then they'll identify those things. So with the 2 clients that I had mentioned, if someone says, look, this person's like a real estate agent, they think they're the smartest person in the room, they won't listen to anybody. I mean, I give them a big disclaimer, which is like, look, this might not be the right case to bring me in on, because I don't think there's going to be a ton of value added, because I don't know how much they're coachable. And then of course the referring lawyer makes a judgment call. If it's like, look, I understand this might totally fall flat on its face and there might be no benefit, but I still want to bring Matt on to see what we can do. Sure, let's do it. Or I give them the big disclaimer and they say, okay, well, let's save the costs on this one because we're just going to try to settle this thing, get the hell out of this case.
Is that how you, when attorneys come to you specifically for prep, do you do it like a case cost, like billable?
Good question. So of course, it all depends on what your fee agreement says with your client. But what I recommend folks put in there is that you have a little carve out section on the litigation costs that say, look, spending 3 days, or well, it's 3 sessions of prep is beyond the scope of your representation. So like, as the lawyer, like I'll prepare you for depo, but like, I'm not going to do a multi-session thing and all this stuff. Like that's outside of my scope of work. And so, yeah, it's a litigation cost. So, you'll front the bill to me. So I get a check from Laiken Law, but then, you're tagging that on the client file as a litigation cost that gets reimbursed in the end. And of course, like the question that everyone wants to ask is, hey, is my client going to get super pissed at the end of the case that there's, it's like one more expert cost on the case, right? Or like, hey, why did you spend that money on my depo? But I've never had that problem. I always feel like at the end of the prep, the witness is so happy that like they got the deluxe treatment, that like, they're always happy with how their depo went. And they go, oh my God, like I'm so thankful that we paid Matt to come on board. And they're perfectly happy to have that be a litigation cost.
I feel like that's something we could hit off at the pass though. Like I feel like if we have that client that we feel like needs that prep, that we could tell them at the outset, hey, you've got a valuable case. And it's really important for your particular case that you do really well at your depo. I think this is a case that we should bring Matt in on. And this is about what it's going to cost. It's going to be a case cost to you that's going to have to be reimbursed when your case either gets settled or if we end up taking it to trial. Are you okay with that? Even if it's in the agreement, I feel like that problem could be dealt with. Is that consistent with your experience?
No, for sure. I totally agree. I have met with other referring lawyers who they just feel more comfortable that comes out of the fee, where they say, look, I don't want to have to tell my client why they need to pay another $2,000 for another lawyer when they're already paying a lawyer from the percentage, right? And I respect that too. If you look at it from that perspective, if you got $100,000 case and your lawyer fee is a third, right? That's $33,000. And then you chip out $2,000 to me for witness prep. That's a pretty small fee split if you think about it, right? So I don't know what's the math on that. Someone who's good at math, two out of 33. It's like, okay, like that, you can live with that. So I see both sides of it, but of course I recommend doing the litigation cost because that way you're not paying for it at the end of the day.
Yeah. So, because this is going to be posted to YouTube and because there are going to be, lawyers outside of JHQ that are going to be watching this, if they're, maybe younger, still building up their practice, can't afford to do something like this, what tips, like quick tips, could you leave them when they are prepping their clients for deposition?
Oh, that's a good one. So first off, you can't do it in one session, period. Like that's like tip number one. Just like you cannot, John and I were just talking about this, is like the client has to marinate, right? Like they have to go home and like think about that day. And then like they sleep on it, and then they come back the next day. Then they sleep on it again, then they come back the third day. Like you can't replace just the process. So it has to be a multi-session thing. And so, I know a lot of lawyers will do like an intro phone call. They talk for 20 minutes and then they meet the client on a different day. That's good, right? It's like multi-sessions. So I feel like every depo has to have multi-sessions. I guess that'd be like the first thing I say. The second thing I'd say is try as much as possible to listen. Like listen. Folks have joked that I give people PTSD from like law school flashbacks because I use the Socratic method all the time.
Okay.
But like, it's true. Like you need to listen and you need to ask questions and then keep listening, because that's how you're going to get to the bottom of problems, right? Like, like your angry client, right? Actually, you're like, dude, just listen, ask questions, like see where that gets you. And you'd be surprised. Like it doesn't take a Johnny Cochran to just listen and ask questions, right? Anybody can do that. You could be a brand new lawyer, just be like, look, you look really angry. Like, what's going on? Like, talk to me. And then by doing that, the client just automatically becomes better at their depo. So I guess that's tip number 2 is just listen. As far as like substantive stuff, when you're reviewing your file to prepare for a depo, I mean, obviously as lawyers, we kind of flag the key problems or the key issues, right? Whether it's like, man, there's a big gap in treatment, or, oh, hey, like there, this is a pre-existing aggravation injury. Or like, hey, the client's been recommended a back surgery, but they haven't got it yet. Like the insurance company is just saying like, if you haven't got it, we're not going to pay for it. And so as the lawyer, you develop all these problem issues, right? But I guess my 3rd tip would be, is that have the client themselves identify those problems. Because as the lawyer, if you're telling them like, look, here's problem number 1 with your case, here's problem number 2 with your case, we got to address these during depo. I mean, that's very negative, and I feel like clients just that almost like creates a fight between you and your client as you're getting ready for your depo.
How do you get them to identify for themselves what the problem areas
are?
They
know. They all know the problems with their case.
Okay.
Ask them. I always give them homework from each session so that they're always like thinking and working on the case, is for them to take some time, think about their case. And I tell them, if they were the lawyer for the insurance company, how would you attack your case? Like, how would you try to defend the case? How would you try to pay less money? What are all the different ways that you'd attack the case? And it's very, very rare that a client doesn't get the problems in their case. I mean, they get it.
And is the purpose of doing that, 1, obviously to not put them on the defensive, but 2, to get them to start thinking about how they will address those issues when they come up in their own words?
Yeah, exactly. So you hit Ashley, you hit the nail on the head. That's the next step. The next step is, okay, we've identified all the issues, or rather the client has identified the issues. And sometimes through guided conversation as the lawyer, you can kind of help them get to that point on their own, without just telling them like what the problem is. But yeah, once you're there, you're like, okay, let's just have a conversation like friends. Pretend I'm your friend and pretend I say, hey, Johnny, I know you say you need a back surgery, but hasn't your back been hurting you for years? Like, how do we know that it was the crash that caused your back surgery and not just the fact that you've got degenerative spine, And then the client will talk to you and just listen and keep asking questions. And before you know it, the client has like answered that defense.
Basically drilling them. You're doing like a depo drill.
Yeah. I mean, you're working through it the whole time and getting them to think about these things and practice that. And then once you have it ironed out, like what they're going to say, then it's just practice. Then you've actually got that distilled. And that's what I call the major truths, is like they, once they're focused on each of those things, they can, that's like ingrained in them. So anything that like contradicts that major truth, like the client's going to not accept and is going to tell the defensive lawyer why they're wrong about that issue or what's really going on.
Matt, thank you. Man, I learned so much today. Like, I'm actually looking forward to prepping my next client.
Yeah, no, for sure.
Thank you.
No, I absolutely love it. And the other thing too is I don't want people to feel like I'm here to make a buck. Like I like doing it, and it's not my bread and butter, right? So I'm doing it because I like doing it. It's nice to have something separate from my own cases to be working on. And so everyone can always give me a call. I'm happy to
and that's exactly where I was going to go. How can people find you?
My website, clendeninfirm.com.
You might want to spell that.
Yeah, right. Yeah, you're screwed. That's a good. I don't market really at all. It's all just referral based. So I always ask folks when I finish a prep, I always ask them to leave an online review. That I feel like that kind of helps build up your presence.
Where do they leave an online review?
Yelp or Google.
Okay, spell out your website name.
Clendenin, and so that's CLENDENIN, Clendenin, and then firm, FIRM.com. So clendeninfirm.com.
And how would you want people to contact you? Through the website, email, phone, how?
Anything. I'm super available. You can text. My firm has texting, so you can text. There's a text line. You can call me. I think my cell phone's listed online. My email's public. I mean, please, just however you want to contact me, it's fine.
Perfect. Thank you. And I know you don't market, but this is marketing for you.
I love it. I already I posted on my Instagram for you.
Great, great. Thank you so much. Guys, thank you so much for watching this week's edition of Justice HQ's Level Up with Laiken. Sending you joy, love, and lots of success this week. We will see you next week. Everybody have a great week. Thanks so much. All right, bye guys. Bye.